no longer news that there was a judicial tsunami when the Apex Court on January 14, 2020, controversially nullified the election of Mr. EMEKA IHEDIOHA as the lawfully elected governor of Imo State. Since that curious judgment, Nigerians from all walks of life, irrespective of political and religious persuasions, have voiced concern over that miscarriage of justice. Little wonder we have witnessed protests even in places like Katsina, Akwa Ibom, Anambra, etc. Commentaries and conversations have not ceased on this troubling judgment. But owing to the fact that there are judicial precedents for review, as no human endeavor is infallible, it is our conviction that their justices will demonstrate courage on Tuesday, February 18, and bring an end to the odium the court has endured and secure the sanctity of our courts. Our demands are very simple, and they read thus. 1, a new panel should look into the review. 2, the court owes Imolites and Nigerians in general the clarity as to what happened to the votes of the PDP and other parties in the 388 units tendered by the APC and its candidate. 3, that the Court of Appeal had earlier dismissed the petition of Senator Hope Uzodinma as incompetent and struck it out. However, the Supreme Court did not consider the appeal of Hope Uzodinma on this point, and so the judgment of the Court of Appeal dismissing the petition still stands or subsists. There was therefore no basis for the Supreme Court to pronounce on the appeal and declare Hope Uzodinma elected. 4, that the judgment was delivered without jurisdiction, in that by virtue of Section 142 of the Electoral Act, once the court says that the election was invalid, the only possible judgment the court is allowed to give is a nullification of the election and not to declare Hope Uzodinma winner. 5, that there was no proof before the court, nor did the Supreme Court state how it arrived at the declaration that Hope Uzodinma met the constitutionally required geographical spread. To meet this requirement, the Supreme Court ought to state the scores and percentages of all the 70 candidates and the contested the elections, local government by local government. This was not done by the Supreme Court, and therefore had no basis and jurisdiction to declare Hope Uzodinma winner of the election. Number 6, that the judgment was a nullity, having been obtained by fraud or deceit, in that Hope Uzodinma fraudulently misled the Supreme Court into holding that a total of 213,495 votes were unlawfully excluded from his votes. The fraud was further orchestrated by the fact that the total votes cast was more than the number of voters accredited to vote. The fraud was further demonstrated by the document tendered by INEC, Form EC40G, which clearly showed that there were no valid elections in the disputed 388 polling units. 7, that the judgment was a nullity because it was given per incuriam, which means that the Supreme Court did not avert its attention to some existing laws and facts, even on the face of the proceedings. For instance, A, by Exhibit A1 from EC 8D, the total number of voters accredited for the governorship election held on 9th March 2019 in Imo State was 823,743, while the total valid vote cast was 731,485. Note that the petitioner did not plead or lead evidence of a different accreditation figure from the 388 disputed polling units. B, with the inclusion of 213,695 votes for Hope Uzodimma and 1,903 to the votes of EMEKA IHEDIOHA as ordered by the Supreme Court, the total number of votes cast at the election now stands at 953,083, which is 731,485 plus 213,695 plus 1,903. That's what brings the total figure to what we had after the Supreme Court declaration, making the total number of votes cast at the election to be far in excess of the total number of voters accredited for the election by 129,340. C, it is unlawful for the total number of votes cast in an election to exceed the number of accredited voters, and that illegality rendered the judgment sought to be set aside null and void. I think this is very apparent. Number 8, the rationale behind the inherent power of this court to set aside its own judgment in appropriate cases was graphically and beautifully stated by Oputa JSC in the case of Adegoke Motors Limited versus Adesanya, 1986, 3, Nigerian Weekly Law Report, Part 109, 250 at 74 as follows. And I quote, "Justices of the courts are human beings, capable of erring. It will certainly be short-sighted arrogance not to accept these obvious truths. It is also true that the court can do inestimable good through its wise decisions. Similarly, the court can do incalculable harm through its mistakes. When therefore it appears to learned counsel that any decision of this court has been given per incuriam, such counsel should have the boldness and courage to ask that such decision shall be overruled. This court has the power to overrule itself and has done so in the past, for it gladly accepts that it is far better to admit an error than to preserve an error. In conclusion, therefore, there is no denying that this is a time of crisis in our country. At this, of all times, our Supreme Court has been afforded this unique opportunity of allaying the fears of those who cast aspersions on the credibility of our courts. Those who mean well for the nation will agree that we have here an opportunity for the Supreme Court to mitigate public misgivings of our courts and to rehabilitate her reputation and restore the good name of the judiciary by setting aside this judgment, which seems to us to be a nullity. Your verdict in this matter should match the solemn oaths you have taken. Remember that every decision of the Supreme Court involves the good name of the judiciary. Proof to the world that the Supreme Court is indeed sacred. Let your verdict help to retain the good grace of our people. This release is signed as below, and we're going to make a copy of this available to all of you here electronically.